actually do have an email question that just came in, and I believe it's going to be from Renee. My 7-year-old and I were hit by a driver who ran a stop sign. My car was totaled, and I hurt my back. My son wasn't hurt bad, just cuts and bruises, but an adjuster from the other insurance came to our home, offered $1,000 for my son's medical bills and $400 for pain and suffering. Does this deal seem fair or not? They haven't offered me a settlement yet for my own more serious injury and said it'll be a while. Renee.
Yeah, Renee.
Les McFadden, that is a softball right there, brother.
I'm about to jack it out of the park, too. That is a terrible deal, Renee. It is a terrible deal. And here's why. Because, you know, when we have people come into our office and they say, well, I've been offered this, I have that, you're talking within days, maybe a day or 2 or 3 within a wreck. At that point, number one, most people have no idea as to the extent of their injuries. They may not have even been checked out by a doctor yet, or maybe they just got a very cursory review of what's going on at the hospital. But what they don't realize is that in the state of Florida, if you're involved in a motor vehicle wreck, you have a type of coverage on your own policy that actually is meant to pay for your medical expenses that are due to the wreck. But it doesn't pay 100% of your medical expenses. It pays 80% of your medical expenses, up to a total of $10,000. Well, if anybody in the audience has been unfortunate enough to be involved in a wreck, you had to go to the hospital, maybe they did a CT scan, maybe they did 2, they come to find out a month or 2 months later when the hospital bill finally arrives, and they see that those hospital charges are $15,000, $20,000, $25,000, and your PIP only pays 80% up to 10, and here you are thinking, you know, a month and a half ago, I sure am glad I didn't take that $1,000 plus $400 for pain and suffering because I'd be out a lot of money.
Or my insurance company paid, and I'm not, you know, my health insurance company paid for my medical bills. I'm going to take that settlement. I'm not worried about it.
Right, and then they find out that they have to pay their health insurance company back something because of a subrogation provision or clause in their contract. That these are the types of things that most people don't even think about.
Right.
Again, it's another reason you want to get an attorney involved, because we understand the insurance policy agreements, your rights, your obligations, your responsibilities. If you have Medicare, if you have TRICARE, VA, Florida Blue, it doesn't matter what your insurance is. If your private insurance ends up paying for a portion of that, there's a very good chance you're going to have to reimburse them at least some of that. And the money that you would normally get out of a claim, some of that has to be earmarked for those liens. And so if you don't protect a lien, you could face fines, you could have your policy canceled.
You could get sued.
You could get sued.
I mean, you could get sued. It wasn't even your fault.
Medicare's fine. You know, we've never had to deal with this, fortunately, but Medicare's fine can be up to $1,000 a day for every day that you've impaired their rights. There's a federal law backing that, and so it can be pretty onerous on it if you don't know what you're doing.
So let's back up just for a second. You made a statement. Your own insurance company is paying 80%. Explain what that is and why Florida is so different than all of our other states.
Right. So Florida.
I think we're in another state. There's two of them.
Florida. A lot of people have heard the term no fault. They go, "Oh, Florida's a no fault state," and they automatically think that means that if you're involved in a wreck, you cannot sue the other person because it's a no fault state. When they say no fault, they're referring to that personal injury protection line of coverage on your auto policy. The reason they call it no fault is because you could be in a wreck. It could be your fault. It could be your fault. It could be that guy's fault. It could be nobody's fault. It could be a deer ran in front of you and you went off the road and you got injured. And it doesn't matter whose fault it is. You get that PIP benefit. That's why they call it no fault. The difference between Florida and 49 other states in this country is that all the other states are a fault-based system, meaning that if somebody else causes a wreck, then their insurance is responsible for compensating you for your injuries and losses. And Florida is kind of that way in a hybrid sense, but that first line of coverage for medical benefits comes from your own policy.
And there's other states that actually mandate drivers on the road have what's called mandatory bodily injury coverage. Right. The trade-off in Florida is, well, we have no fault, which, you know, you get the first $10,000 to pay for your medical bills, and after that, there's nothing, and we don't require anybody on the roads to have mandatory bodily injury coverage.
That's right.
And so there's several situations that we come across weekly where good people have been involved in an accident, and it could just be a total, just a total careless situation, no fault of anybody's. And they don't have uninsured motorists, and we can get into that in the second segment here, Les. But because the mandatory bodily injury coverage is not imposed in the state of Florida, there's nothing for them to recover. And so it makes it very, very difficult. It makes the conversations that we have with our clients very, very difficult. And it's kind of like what we were talking about with sovereign immunity. You don't understand it until it happens to you.
Right.
And every day we have people walk through our doors that we're taking care of, week in and week out, who are we're having to educate them on this system because a lot of them are first time.
It's very unfortunate, you know, because usually you find that out after the fact, and there's nothing you can do about it.